looking at the wrong column.
We are? Did I print it out wrong?
No.
No, we might.
Yes.
Are we live?
Yes.
Okay.
I'll tell you later.
Okay. All right. Good evening, everyone. The public hearing on ordinance 9118 is now open. A public hearing is a meeting that provides the opportunity for public discussion regarding ordinances and other matters pending before City Council. Today, ordinance 9118 is at issue. Ordinance 9118 amends sections 150.85, 150.87, and 150.89 of the codified ordinances of the City of Bowling Green. Interested parties may express their views and submit evidence supporting those views at this public hearing. The information shared will become part of the city's permanent record and may be used by members of City Council in deciding whether or not to adopt the ordinance. There are usually 4 parts to our public hearing. The first, a staff report. The second, any applicant's testimony. Third, public testimony. And fourth, discussion by members of City Council. To start, we usually receive a staff report from Planning Director Heather Saylor and the applicant's testimony. But because there is no applicant here, and because this legislation amending our zoning code originated with and has been proposed by Council President Hollenbaugh, we're going to jump straight to testimony from the public tonight. So Jody, first, I guess, is there any correspondence on this ordinance?
No, there's not.
Okay. So are there any members of the public who would like to address the committee at this time? If so, please make your way to the podium. Thank you. You're welcome.
Good afternoon, David Maurer, 1019 West Wooster Street, Bowling Green, Ohio. First of all, I wanted to just point out, in July, we have a new zoning ordinance here in the city of Bowling Green, just passed. I know it took a lot of work by a lot of different people, and I know that a lot of people are still wrapping their heads around it, much like myself. These types of things, there's 130 pages of gobbledygook, and I think now we're looking at an ordinance, and I'm speaking about an ordinance here today that purports to take away certain grandfathered uses. I think it would make a lot of prudence, a lot of sense to give it some time, let people figure out what's in the new zoning code before we start taking away grandfathered uses. I just think that would be more efficient and make a lot of sense. Now, my comments as it relates to this particular ordinance, good legislation, in my opinion, should be built on a solid footing foundation of truth, certainly not on a false narrative. This legislation, I've read it a couple times. I still don't know if I understand all of it, but from what I understand, this legislation is not built on what I would consider truth. I don't think it serves a legitimate government interest. I'm going to start with the preamble. This ordinance purports to protect real estate from impairment and destruction of value. I think it'll have just the exact opposite effect. I think it's going to decrease value, specifically the properties that it's going to target, specifically the grandfathered properties. As soon as this ordinance passes, it will diminish the value of those properties immediately, in the hope that in 21 years, that it's somehow going to increase the value of neighborhoods. Now, of course, that's very speculative and hypothetical. I don't think anybody in this room can tell me what that value is going to be in 21 years. If I'm around in 21 years, I hope to see this increased value, but I do know that it will diminish the value of property today. As soon as that ordinance is passed, those properties will be worth less money. Second, this ordinance purports to protect the appearance of the city and maintain the aesthetic harmony of the community. I don't know what the aesthetic harmony of the community is. I don't know how you measure that exactly. Maybe with a yardstick. I don't know. I don't even know what that means. This ordinance is supposed to revitalize the blighted areas located within all residential districts. This one, I really have a problem with. Blighted areas in Bowling Green, I need somebody to show me where those areas are. I've been here 40-some years. I've lived, born and bred in Bowling Green. I don't know where the blighted areas are in Bowling Green. I thought maybe I didn't understand the meaning of that word. I thought maybe an independent party could help me to understand where the blighted areas are. So I called an unbiased third party, the Wood County Auditor, who else better know where the blighted areas are than the people who actually set the value of properties in Bowling Green. So I spoke to somebody at the auditor's office, and as many of you know, they're going through their triannual reappraisal. And so many of you who have looked at their website have seen that your property values have gone up. I think it was reported in the BG Independent News that property values have increased by about 24% over the last 3 years. That's countywide. So I asked the individual I talked to at the auditor's website, at the auditor's office, specifically, what percent did the properties in Bowling Green increase in value? What percent increase in valuation did we experience in the city of Bowling Green? I just assumed it had to be lower because everything I hear is that BG has very blighted and terrible neighborhoods. I was told that, in fact, the city of Bowling Green pulls up the county average. The city of Bowling Green property values increased 25%, which is on par with Perrysburg. That was 25% over the last 3 years. And I thought, well, maybe that's just an aberration because I hear so much from community groups about how the housing stock in Bowling Green is so terrible. So I asked, well, what about 2020 at that valuation? So this would be the valuation from 2017 to 2020. What about that period of time? And I was told that the increase in property values in 2020 was 13% in the city of Bowling Green, again, above the county average and commensurate with Perrysburg. So in the last 6 years, property values in the city of Bowling Green have increased by 38%. So again, I question, where is the blight that I hear about that's in this ordinance that we need to start passing ordinances to correct? I don't see where it is. In fact, just the opposite. Property values in Bowling Green are going through the roof. 38% in 6 years. To me, that's pretty good. The fact of the matter is, for this particular ordinance, I believe it to be an attack on renters. I believe it to be discriminatory against college students. I think it sends a message that college students are second-class citizens. Because they're the ones that are going to be affected by this, not families, college students. They come here for an education. They spend the money at our shops, at our restaurants. They invigorate the community, and I think that they're not treated the way that they should be. Things like this ordinance would increase the cost of living for renters. It would decrease housing options for renters in a period of time where we need housing options more than ever. I've heard from a lot of people around town that we have a lack of affordable housing right now. Why are we taking housing options off the table? Looking towards the future, I think that we need development, we need investment in the community to provide housing. We have Abbott Industries coming in, I think, just over a year. We need housing options for that workforce. We don't need to be taking housing options off the table. In fact, just the opposite. Most people, including landlords, love Bowling Green. They care about Bowling Green. They want to invest their money in Bowling Green. In order for that to not happen, I think you have to give people a reason not to invest their money in Bowling Green. It's a great community. I think this gives them a reason that people might step back and say, well, it doesn't seem very business friendly. You're taking away property rights from people. I think licensing and inspection sends that same message of rental properties when you have free inspections by the building department, health department, fire department. I think that we should be sending a different message to investors and developers that BG is welcoming and a welcoming community for their investment dollars. Landlords do not want their investments to decrease. That shouldn't be a newsflash to anybody. They care about property values just as much as homeowner occupied individuals. And I think that this ordinance would hurt the very people that need affordable housing the most, which would be renters and college students. Thank you.
Thank you, Mr. Mauer. If you could just stand 1 second. Greg, Nick, any questions for Dave before?
No.
Okay, thank you so much.
Thank you so much. Appreciate it.
Is there anyone else who would like to address the committee at this time? Okay, come on up.
Hello, am I doing name and address?
Please.
Okay, Caitlin Elliott, 219 Crim Street. I spoke at lobby visitation earlier, and I was told that my interpretation of the law was not necessarily accurate, and that it was about occupancy based on bedrooms and not changing how many units could be in a house, let's say. But I did find, I wanted to share, I found the BG News's coverage of the law in 1989 and printed it off if anyone was interested in that, because they do talk about how that was about occupancy and only allowing 3 unrelated persons per bedroom. So I know we'll all get it figured out and we'll know exactly what this law does or doesn't do. But if anyone's interested, I have the...
Sure. Thank you, Caitlin.
Mr. Harold isn't here, but he's mentioned.
Thank you.
Thank you.
Thank you. Is there anyone else that would like to address the committee at this time? Coming up.
Hi, my name is Rose Drain. I live at 228 East Court Street, and thank you for having the public hearing to give us the opportunity to address concerns and also praise for some aspects of the proposed ordinance. As you know, I'm a member of BG Strong. Our members did not reach a consensus regarding the proposed ordinance, amending sections 150.85, 150.87, and 150.89 of the city's code. I'm here to speak for our group on what we see as admirable about the proposed ordinance, as well as the flaws, which one person from our group described as almost absurd weaknesses. I am hoping you will consider amendments to address these before voting on the proposed ordinance. Among the members who reviewed of our group who reviewed it are 2 former city council members and a former chair of the city's planning commission. Some of their comments. My response is simply that it is hard to get excited about an ordinance that goes into effect in 28 years. As it stands, any positive impact will be a generation and a half away. I think the only avenue worth pursuing is whether this amortization period can be reduced. Another member brought to our attention the amendment to section 150.87. The time period that an owner's voluntary discontinuance of nonconforming use that would result in forced compliance has been changed from 6 months in the current code to 2 years. Why? Allowing a property to sit idle without ramifications during 24 months rather than a quarter of that time is, in his words, outrageous. A third thing that caught our attention is language in 150.85G that allows nonconforming alterations if they, quote, are erected pursuant to a city permit, unquote. Why the sudden and unexplained reference to city permit rather than to exceptions allowed by the Board of Zoning Appeals as cited elsewhere in the proposed ordinance? A basic question. If a property owner for income purposes has reached the amortization period allowed dictated by the IRS, why should the nonconforming use be allowed to continue when the property is sold or otherwise transferred to a different owner? There is a legal precedent in regard to prohibiting the continuance of nonconformity when there is a change of ownership of a property. Can that be added as a stipulation to this legislation? So, those are our objections. On a brighter note, we do find plenty to applaud in the proposed ordinance. The stated goals of protecting the appearance of the city as a whole, promoting revitalization and injecting vitality in all of the city's residential neighborhoods, protecting the value of residential property, lessening overcrowding of residential neighborhoods in respect to the occupancy of living units, congested traffic, parking problems, overly burdened municipal services, and the general decay of the community atmosphere in neighborhoods caused by overcrowding and overuse of structures. We wholeheartedly agree with the bold statement that pre-existing uses with respect to the occupancy level of structures contribute to blight conditions that impede the revitalization of the declining neighborhoods in those districts. Mr. Mauer asked, where is the blight? Well, we recently sent out a dozen volunteers to areas in the PR district on the west side of Main Street. The East Side Association covered the east side of Main Street. And we asked people, as did East Side Association, to make note of what they saw in terms of the condition of the rental properties that they visited. One member said that along South Main Street, she noticed dirty windows, broken storm doors, missing screens, deteriorating stairs, unpainted outside exterior surfaces. And some of those we are reporting using the city's new problems button that's available on the city's website. So that's, there is blight, and I guess you have to get up close to see it. We think that people who are living in rental properties deserve decent living conditions, and that is not uniformly available to rental residents in our city. That is something that our group wants to work on, as well as the availability of more standalone homes that are appropriate for a family, whether it be a renting family or an owner-occupied family. Where have all the children gone from our neighborhoods? If you know Bowling Green as I do, having lived here since 1967, these central residential neighborhoods were populated with families who had children. And it's dismaying to see that that is no longer the case with our city. Continuing on with the word blight. The words blight and nuisances are used over and over in the proposed ordinance. In writing this legislation, you've made a strong statement that you want, as do the members of BG Strong, something better for our city in regard to the condition of housing than what we've got. You have opened your eyes to the blight and brought it to the attention of residents, business owners, and investors. An effective date for this ordinance of December 31st, 2051 is a long, long time to put up with blight and nuisances. We are asking you now to do something more effective about fixing these problems so we can all enjoy a city that we're proud of and want to live in. Thank you.
Thank you. Any questions for Ms. Drain?
No.
Okay, thank you. Is there anyone else here who would like to address the committee at this time? Okay. So we are now at the part of a committee hearing or a public hearing where members of council will discuss the ordinance. Greg or Nick, any thoughts? Just Rachel. Yeah.
Rachel.
Yeah.
The 28 years, this is in coordination with Ohio state law, correct? I mean, maybe we.
Please.
The 28 years is meant to encompass the depreciation period allowed by the IRS for real estate improvements. So that in theory, if you pass this thing today and somebody bought a property that's grandfathered for occupancy, they could still depreciate the property down to zero and there wouldn't be a taking. That's the theory behind it. That's where the 28 years comes from. So it's a little different than what was proposed back in the 80s by Councilman Pond for that reason, because the depreciation schedules were different then. The other difference is his ordinance was meant to, I guess, address all non-conforming uses in the city, not targeted at one particular type of non-conforming use. So that proposal in 1989 or whatever it was very different in that respect.
Great.
So that's why on the two things. Does that answer?
It does,
Well, you're
yes.
at-
I appreciate that. Thank you. That answers my question.
Okay. Greg?
Well, I hate to ask you to get back up again, but I didn't know it was, since you were,
I'm old, Greg.
well, you know, there's a station over there you could sit and talk to that.
Is that right? I don't know. First
And
time
then-
I've been in. First time I've been in here, so I walked in the door and sat down.
So you used the phrase non-conforming due to occupancy, but it's my understanding that now that we have in our new zoning code codified Yoder and made it clear what occupancy means in accordance with Yoder, that we really don't have, I mean, that supersedes any previous
Yeah, but
designation as non-conforming, because all properties, whether they were ever called non-conforming for occupancy, all have to comply with our new code.
except that if they pre-exist the new code and they were legal non-conforming uses can continue. So just pick one. I don't know. There's a house on East Worcester Street I'm thinking of now that's been legal non-conforming for 8 occupants for years, predates the 76 ordinance. Your new zoning code does not make that any less legal non-conforming.
All right.
See what I mean? That's, I believe, what the target is for this ordinance. Properties like that. I have no idea how many there are, maybe, I don't know. We used to have a record of non-conforming properties that we knew about what they were. But, and maybe that addresses what you were talking about. Your 1989 article was really describing a different ordinance. Yeah,
Okay. No, thank you for that.
yeah. So there are going to be still, in spite of your new ordinance, there will be legal non-conforming properties that can continue. Right now, the reason the ordinance was written with an exception for city permit, maybe that wasn't very artful, but there are properties that are over-occupied under the code, but by virtue of having a variance granted. And so that was intended to say those could continue because they were done by city permit. I don't know if that answers that. You didn't ask it, but someone, I don't remember who, someone asked why that's in there. That's why.
Thank you. You've answered my question.
Yeah.
Any other questions for Mike? Thanks for joining us today, sir.
Yeah, thank you.
Well, there's a new baby in the Brown family. I don't know if you knew that. So,
Learned today.
yeah, they had a baby girl. 7 pounds, 3 ounces. Preneat. Yeah, good for them.
Congratulations to them.
Okay, any more discussion on this ordinance at this time?
Well, Heather, do you have the number of properties that would currently be non-conforming but have been approved in our zoning code?
So I had talked to Rachel earlier this week with that same question, and I always think the stipulation is the best list we have at the moment. I mean, these are always changing. You know, there's thousands of properties in the city, so this is the best capture that we have at this moment. So looking at occupancy only, I counted about 22 properties. And we have dropped some off the list since, as you mentioned, the Yoder case, getting that codified, also the new zoning code. And then, of course, BGSU has bought some properties right along East Booster Street and demolished those. So those would also be removed from our list. So it has dropped down, I would say, significantly.
Thank you.
Greg, anything else?
No.
Okay. Thank you, everyone, for your participation this evening. This concludes the public hearing on ordinance 9118.